Okay, so let me get this straight. Send. Chris Coons just sat in front of Trump's federal judicial nominees, people about to get lifetime appointments to the federal bench, and asked them one of the simplest constitutional questions there is. Can Donald Trump run for a third term? And the answer he got back, I am not making this up, was that this strikes as more of a hypothetical. It is not a hypothetical. The 22nd Amendment is 6 sentences, plain English, ratified in 1951. And these are the people about to put on the robes for life. So watch this clip, then I'll break down exactly how bad this got. Hit subscribe right now so you don't miss it.
Senator Coons.
Thank you, Chairman Grassley, and to each of you and your families, congratulations. And thank you for raising your hand to serve and in some cases continuing to serve the public.
Thank you.
Mr. Mark, if I might, just tell me about the 22nd Amendment. What does it provide?
The 22nd Amendment, Senator, my career has mostly been in criminal prosecution. I haven't had an opportunity to use that one specifically.
Anyone able to help on the 22nd Amendment to the United States Constitution?
Well, Senator, I believe it is the amendment that deals with a 2-term limitation on
Correct.
the service
It
of the
states
president.
no person shall be elected to the office of the president more than twice. Mr. Mark, is President Trump eligible to run for president again in 2028?
Senator, without considering all the facts and looking at everything, depending on what the situation is, this to me strikes as more of a hypothetical of something that could be
It's not a
raised.
hypothetical. Has President Trump been elected president twice?
President Trump has been certified the President of the United States 2 times.
Is he eligible to run for a third term under our Constitution?
I would have to review the
All I need to
actual
tell
wording
you
of
is
it.
the language of the constitutional amendment that makes it clear that no, he is not eligible to run for a third term. Anybody else brave enough to say that the Constitution of the United States prevents President Trump from seeking a third term? Anybody willing to apply the Constitution by its plain language in the 22nd Amendment? Nobody. All right, let's move on. Mr. Coons, what is res judicata? How does it apply?
It's a judicial doctrine that prevents a judgment that has been, in one case, it applies to you can't go into court after a final judgment in one case and have it and litigate the same things again.
How is that distinct from collateral estoppel, which precludes litigating the same things?
Res judicata, one involves the same party, the other involves the same things.
And what's a requirement for these two doctrines to apply?
Notice, opportunity to be heard, final judgment of a court of competent jurisdiction.
Anyone disagree? If I might, Mr. Coons, is it pronounced the same way mine is?
Yes, it
Coons?
is. Yes, Senator.
My family's name was spelled that way when we came to the country. So, you were one of 3 judges on the panel in Alexander v. Trump, where the president was suing the Pulitzer Prize Board for defamation. When did your work on that case begin? When were you assigned this case to decide?
I first learned of that case in approximately January of 2025.
Not when the briefs had been filed?
No, Senator. The way it works in our court is we are not assigned cases when the briefs are filed. Once the case is ready for disposition, the clerk randomly assigns it to the judges in the court.
And when did you first speak to Senator Scott's office about your interest in a district court seat in the Southern District of Florida?
I mean, I've had many conversations with Senator Scott's office. The one about an interest in the Southern District of Florida, I believe, was in November of 2024. I don't know the date, but it's in my Senate Judiciary questionnaire.
And when did you release the opinion ruling President Trump's favor in this matter?
So I learned of the case in January of 2025, and the opinion was released in, I believe it was February 12th, 2025.
That's correct. So you issued an opinion where one of the litigants before you was the president and in favor of the president while you were in active conversation with the senator's office about seeking a federal judicial appointment. Is that correct?
For a position I did not, in fact, get, Senator.
How did you end up in front of me today?
It's a different position, Senator.
Did you consider recusing yourself from that particular decision?
No, and the canons that govern us in Florida, Senator, as I believe this committee has previously heard, it did not call for me to recuse myself. I did not have an interest in the litigation, and none of the basis called for recusal, and the Florida Supreme Court instructs us, the appellate judges, that we are not to recuse unless one of the bases in Canon 3 exists.
Does the Florida canons not require you to recuse if one of the parties before you has an interest that could be reasonably concluded by any common citizen to cloud your judgment on that matter?
Senator, I disagree with that characterization. I had not heard from the White House until after the opinion was final. I had only spoken.
When did you interview with the White House counsel's office?
At the end of February of 2025. I don't know the date, but I believe it's in my Senate Judiciary questionnaire.
Thank you for your testimony on that matter. Mr. Hendershot, if you would just take a minute and talk me through again how collateral estoppel and res judicata are different from each other.
Senator, I'm not sure I can improve much on Judge Coons. I think that often res judicata today is used as sort of a catch-all term, but generally I think the difference is between claims and claims that may have not been brought but could have been brought potentially.
Right.
So collateral estoppel and res judicata is more a thing actually decided, as the Latin would suggest.
Thank you. Do you agree that judges should not be influenced by external pressure to rule in any particular way?
Yes, Senator, I do.
President Trump stated March of this year at a public event, quote, "We have rogue judges that are criminals. They're criminals, what they do to our country, the decisions they hand down and hurt our country. Is it possible for a judge's decision to be correct as a matter of fact and law, even if it differs from the president's desired outcome?"
Senator, I want to tread carefully because of Canon 5 in terms of commenting on political matters. But in the abstract, yes, decisions can be correct, and any citizen can criticize what a judge has done. That is, I think, part of their right to speak.
Thank you.
All right, so let's start at the foundation. The 22nd Amendment was ratified in 1951. The operative language reads, "No person shall be elected to the office of the president more than twice." That is the entire ballgame. There's no asterisk, no interpretive war in the federal courts, no scholarly debate. It is one of the most plainly written amendments in the entire Constitution. And these are people applying for lifetime federal judgeships. And watch what Mark does. He calls it more of a hypothetical. No, it isn't. A hypothetical is what happens if a sitting president is incapacitated midterm. The 22nd Amendment is settled law ratified 75 years ago. Coons literally reads him the words. Mark still won't apply them. Then Coons opens it up to the entire panel. Anyone brave enough? Silence. 4 nominees. 0 hands raised. Now this part is where it actually gets ugly. Federal judges are bound by 28 U.S.C. section 455. The test is not whether the judge personally felt conflicted. The test is whether a reasonable observer could question their impartiality. That standard exists for a reason, and Florida state canons don't override federal expectations when you are being vetted for a lifetime seat on the federal court. So here's the Hendershot timeline. November 2024, he's already in conversations with Sen, Scott's office about a federal judgeship. January 2025, Alexander V. Trump gets randomly assigned to him. February 12th, 2025, he rules in Trump's favor. End of February 2025, he sits for an interview with the White House counsel's office. He never once recused. And his defense, on camera, was that the Florida canons didn't require it. Article 3 gives federal judges lifetime appointments for exactly one reason. So they don't have to fear political retaliation. So they can rule against a sitting president without losing their livelihood. That is the entire architecture of the federal bench. And in March of this year, Trump stood on a stage and called federal judges, his exact word, criminals. They're criminals. That isn't criticism. That is pressure. And then listen to how Hendershot answers. Can a judge's decision be correct, even if it differs from the president's desired outcome? His answer? In the abstract, yes. In the abstract, he had to qualify it. A federal judicial nominee sitting under oath couldn't simply say yes. That right there is the entire problem of this hearing in one sentence. And look, none of this is random. It's a pattern. 4 nominees, 4 fumbles, every single one pointing in the same direction. Won't apply the 22nd Amendment. Won't recuse from a Trump case while interviewing with the Trump administration. Won't say plainly that judges are allowed to rule against the president. It is like interviewing for a lifeguard job and refusing to commit to whether saving the swimmer is, actually required or just kind of preferred. The whole point of the federal bench is that nobody should ever have to ask. The independence is supposed to be baked in. And the Senate is about to confirm people who literally cannot articulate that on camera, under oath, in front of a working microphone, on a Wednesday afternoon in 2026. And then we get to the part that should have ended this hearing on its own. Coons asks about res judicata and collateral estoppel. These are 1L civil procedure doctrines. Every law student learns them by November of their first year. Federal judges apply them constantly to dismiss frivolous suits. And Mark fumbled the basics. Coons, the senator, ended up explaining them better than the nominee. So here is the line. Next time someone tells you this hearing was political theater, ask them one question. Why couldn't a single Trump nominee read the 22nd Amendment out loud and apply it? That is not theater. That is the answer. Hit like, subscribe, and share this with someone who needs the full picture. I'll see you in the next one.